seated. We're on the record, State of New Jersey versus Paul Caneiro. It's indictment 19-020283. Can I have the appearances of counsel for the record?
Good morning, Your Honor. Assistant Prosecutor Nicole Wallace on behalf of the state.
Good morning, Judge. Chris Decker, Assistant Monmouth County Prosecutor for the state.
Good morning, Monica Mascalone, on behalf of Mr. Paul Caneiro, who's present.
Good morning, Judge. Good morning, Mr. Caneiro.
Okay. So, yesterday, Caitlin Caneiro was on the stand, and during the course of her testimony, a few things came out that gave the court some concerns, and there was some objections that were made. As it relates to the testimony, I'm going to reiterate it. To start with, this deals with the Jennifer's phone and Caitlin testifying about the phone call that she made on the day of the incident. It starts off with defense counsel, specifically with respect to Jennifer's phone, was her phone ringing? Witness says, yes, it rang normally, then went to voicemail. Defense counsel, what was the approximate times you were calling the phone calls, the phones that morning? Witness, I would say from 9:30ish to 12. Defense counsel, okay, that's approximate. Answer, yes. Defense counsel, okay. And to your recollection, did Jennifer's phone ring? Answer, yes. Monica, or defense counsel, were you also sending text message that morning? Witness, yeah, I texted my Uncle Keith and I texted my Aunt Jen. Question, do you remember the time that you sent your Aunt Jen the text message? Answer, no. Question, no. Answer, no. Question, would seeing a copy of the text message with the timestamp help refresh your recollection? Answer, yes. Question, I am approaching with what's been marked as D1-54. I'm just going to direct your attention to the name. Answer, okay. Question, and the specific text with the timestamp? Okay. I think it's D54. Question, okay, does that help refresh your recollection of what time you sent the message to your Aunt Jennifer? Answer, yes. Question, and what time was that? Answer, 10:26 in the morning. Question, okay, now what kind of phone does your Aunt Jennifer, what kind of phone did your Aunt Jennifer have? Answer, she had an iPhone. Question, and do you still have that text message in your phone today? Answer, yes. And did you look at that text message recently in the last day or two? Answer, yes. Question, now prior to the last day or two, when was the last time you looked at that text message? Answer, the day I sent it, November 20th, 2018. Question, so you haven't looked at the message since? Answer, no. Question, when you looked at it in the last day or two, what, if anything, did you notice about the text message or iMessage? Is it a text message or an iMessage? Question, or excuse me, answer, it's an iMessage and it changed from delivered to read. Question, okay, so do you have any idea what that would have changed? So do you have any idea when that would have changed? Answer, no, I didn't look at it for 7 years. Question, now the fact that it said read, did that stand out to you? Answer, yeah, because who read it? I wasn't allowed to read it. That deals with the testimony. At the original moment in time, the prosecutor did not object, however, did object last night as a result of not just this colloquy back and forth, but the next colloquy that goes on the record, which deals with Jesse's iPad. Question, again, same witness, Caitlin Caneiro. You mentioned earlier Jesse's iPad. Answer, yes. Question, let me ask you this first. Did did anyone in Jennifer, Keith, in your family share their locations with you? Answer, Jesse. Question, and was that tied to his iPad? Answer, yes. Question, okay, at some point, did you check the location of the iPad? Answer, yeah, in February of 2019. Question, okay, so this is a couple months later? Answer, yeah. Question, and where was when you checked the location, what was the location? We went to sidebar. This is when we learned that when the proffer came out. And we were informed at sidebar that when she checked the location, that the location would read from Corey's house. And that was the first time that the defense put the state on notice of that information. The state had objected to that information. I had the opportunity to do some research on it yesterday during the time frame, but unfortunately, due to the fact that this information was sprung on everybody, including the court, I had indicated that I would accept briefs from counsel. That they were due by 10 o'clock last night, leaving the court between 10 p.m. and 8 o'clock this morning to come up with a decision as to this. I've reviewed the state's brief, which I received somewhere around 8 o'clock last night. It was authored by Mr. Decker for the state, in which the state argues that it was concerned about the actual two items of evidence, both being what was testified to and would be stored within the witness's phone, to include the actual text message that was marked red and also the location. In the state's position, the state indicates that this runs afoul to what was contemplated by the Supreme Court in Tier. They cite to a particular portion at the end of the Tier opinion, which says that we encourage practitioners to participate in cooperative discovery in order to ease the burden on all parties involved. But really what the state is relying upon is the fact that because this information was electronically stored in the witness's phone, that this information should have been turned over to the state, which it never was, and because it was not, that the remedy is now exclusion with an instruction that they should disregard the testimony. Then received it at 10 o'clock last night, the defense's response, and the defense's response for the first time, defense counsel admits that she had an actual screenshot of the phone message, the text message, which indicates that the text message was read, that the screenshot was provided to her, according to her, the day before, and that she decided not to use it due to its late hour, and decided not to turn it over. That was her decision that she made, which is clear from her submission. So we'll deal with that issue as number one, as whether that is a discovery violation or not. The second issue deals with the issue of the location of Jesse's iPad. The defense is arguing that this testimony is relevant because it demonstrates that Corey was taking items from the house after the homicides, which lends to certain credence about that the scene was contaminated during the cross-examination of Detective Vogt about these Tiffany jewelry boxes found on top of the rubble. But, of course, this was dealing with when Vogt collected the DNA samples in 2020, not in 2018. Second, the state argues that it demonstrates, that this evidence demonstrates a failure to investigate because the state did not seize or search the iPad while they did seize and search Sophia's phone. The defense argues that the state, and I should stay there for a minute. In pointing this out, I want to go back for a minute to the text message. There was one thing I did want to add to that. In the submission, no, I don't need to go back. In the submission, it also points out that that when Katie learns of the location in February of 2019, that she sees that the location was at Corey's house. There's a footnote that the defense counsel talks about, which says, it should be noted that defense counsel further recalls the witness mentioning that she confronted Corey about it either via text or phone once she saw it that he had the location and asked him why he had taken Jesse's iPad. That is the first time and only time that the court is aware of that either there is a documentation in a phone of either a text message or a phone call in Caitlin Caneiro's phone that could corroborate or provide information that could be investigated as it relates to the issue of whether that occurred or not. That either text message or phone call was not turned over to the state, and if it was turned over, they can tell me when they start to argue. I should point out that the defense is, in saying everything that I've summarized so far, the defense is saying that they are not suggesting that the iPad was taken at the time of the murders, as it was clearly depicted during the testimony of the forensics detective when he went through the evidence found in the kitchen, where there was an iPad located there. The iPad, I guess based upon what defense counsel is saying, is that the iPad that's located in the kitchen is actually Jesse's iPad. I don't know if that was clear during the testimony at all, that somebody said specifically that they knew that it was Jesse's iPad, but that also is something that's being argued. But what the defense is saying, that they were trying to be careful to make clear to the jury that Katie saw the location in February 2019, a few months later, so not to be misleading. However, there was no context to this as to when, at that point in time, how long that the location was at Corey Caneiro's house for this iPad. It truly was unclear because we didn't get that far based upon where we were. Defense counsel further argues that the state had full access to Susan, Katie, and Marissa, that the state had the ability to interview them just as much as the defense did. However, what's interesting to note about that is that it's clear from this submission, and it's noted specifically as a footnote, number 3 on page 4 of the defense's submission, that the defense was aware that the state was making efforts to speak with Susan and to Katie and Marissa close to the time of trial to make a decision on whether probably if they were going to call them or not. However, that none of them were willing to speak. So the state did not really have access to them. So when it comes to the defense putting in their submission that for the weeks during the course of the beginning of this trial that they were not sure if the state was going to call the either Susan, Katie, or Marissa, the court has some level of concern of that statement based upon the fact if the state had no idea what these individuals were going to say, why would they call a witness that they have no idea what's going to come out of their mouths other than a statement that was given 7 years ago, but now they're unwilling to speak to the prosecutors. So I'll leave that for another day, or for the state to deal with if there's something that should be added. I'll point out that while the state did have Susan, Katie, and Marissa are all on their witness list, the witness list is a list of people that may be called. It's not it's more people that are ever involved in a case. The witness list is used not just for the potential witnesses, but it's also for the jury to know, to be read each individual's name, so that if one of the jurors happens to know one of these individuals that may not be called as a witness, it's still important for the court to question those particular jurors as it relates to that issue, on whether that if they knew that person, even if they're not being called, would that have impact their ability to be fair and impartial? So the fact that the Susan, Katie, and Marissa were on the state's witness list is of no moment to this court as it relates to them being there, and as to whether that there was an obligation here to turn over this type of evidence. I also want to point out that counsel brings up the fact that, well, this trial is moving exceedingly fast. I just want to say that I've disagreed with that from the door. I gave the March 20th date because everybody indicated that that's how long the trial would be. It was never what the court thought how long this trial was going to take. As the trial went on, it was clear that this case was moving quickly. As early as the first week, it was clear that this case was not going to take as long as what was being said of March 20th. So I don't find that the movement of the case in an expeditious way was any surprise to any of the parties as we move forward as to when the prep of Katie was done, or how ultimately we come to the conclusion of where we are today. So defense also talks about state versus tier, and I'll get into that when I give my ultimate decision. And lastly, the state says that it doesn't believe that it violated any reciprocal discovery, but if it did, that it should be a brief continuance instead of a violation that bars the actual testimony. And there was 2 exhibits that were supplied with the defense's submission, which includes, again, a photograph. In Exhibit A was a photograph of the kitchen area where the defense is indicating that Jesse's iPad was located on there. And then, again, that's what the defense is saying. And then second was the actual screenshot that was never turned over. I summarize what people have said so that we don't need to reiterate the actual arguments. However, considering that the state submitted their submission before the defense, I don't know if there was something else that they wanted to respond to, but I'm going to allow both sides to create their record before the court makes its ultimate determination. I'll start with the state.
Thank you, Judge. Now, I just want to start off by saying that I think that the court's summary with respect to the issue that came up yesterday and the court's summary of what was stated in the briefs is spot on. I mean, I think that the court essentially hit every point that the state would have argued. Obviously, the state and the defense in any case have different discovery obligations. We're all aware of that. But that does not mean that when you are in possession of a document that you decide not to turn over because you weren't going to use, that doesn't mean that it's not a discovery violation. I mean, they did use it. They didn't use the physical document, but they used the information in there. That's where the state has a problem. I don't want to get on my high horse, Judge. I'm not going to belabor the fact because the court's spot on in its insight with respect to everything that it said this morning. But as someone who's been with the prosecutor's office for almost 23 years, especially in the last few years, I've had to sit back on cases that were not mine, some of which I then had to get involved in, where the prosecutor's office was being accused ad nauseum of these heinous discovery violations, when in effect, a lot of times it was essentially some sort of minor oversight, clerical error, but yet in the press, the state and the prosecutor's office was looking like the demon, the villain. I'd submit to this court that over the course of the last 7 years, this office, myself, Ms. Wallace, paralegal team, our clerical staff, have done everything possible to make arrangements to provide discovery to the defense. I've been personally, not by these attorneys, personally had my credibility tarnished, or attempted to be tarnished, by a prior attorney for Mr. Caneiro, wherein I had to write a very scathing letter pointing out that in fact we did not have something at a certain point that we were accused of having and not providing. We've provided discovery. It's been gone over ad nauseum by Your Honor, by Judge Oxley, every status conference. Is there any other discovery? We've done everything we can. I'm not trying to make this more than it is, but I think based upon the submission that we've received from the defense, certain things are clear with respect to what they had, and I would submit to the court, as I stated, that I don't believe that the New Jersey Supreme Court intended for their opinion to mean that, hey, let's not document it because then we don't have to turn it over. I don't believe that's consistent with the language about encouraging practitioners to participate in cooperative discovery, etc. It's pretty clear what we have here. It's a clear situation. The court's insight is spot on with respect to the Susan and Katie and Marissa. A lot of what Ms. Massalone said is accurate. We did make attempts, and just because we didn't, Detective Petrozello or Detective Weisbrot didn't document every effort over the course of the last 7 years to make contact with the family, doesn't mean it didn't happen. They know it happened. We tried our best to not harass them, certainly, but we had made efforts. Ultimately, it culminated with, we were supposed to meet with them on the Friday before the first trial date in September, and it was canceled because we were here arguing whether or not Mr. Caneiro would be released. Then, prior to trial, we made efforts again. I did speak to Ms. Pastalone about it. She said that she was in contact with them and would tell them to give us a call. Ultimately, Ms. Caneiro called Ms. Wallace back and indicated that she didn't feel comfortable talking to us. So, they were on our witness list, yes, but as the court properly noted, that we can't put witnesses on the stand when we don't know what they're going to say, i.e. exactly what happened yesterday. This is not information that was provided to us. It was not known to us. We would have objected to the first part of the testimony yesterday had we known it was coming out, which we did not, obviously. And then, obviously, it became clear with respect to the iPad location and that clarification that she saw it in February of 2019 does nothing to clarify to this jury when that iPad was taken by Corey Caneiro or his wife or whomever who actually had control of the property after the scene was released by virtue of the executive status. That being said, Judge, I'm not going to belabor this anymore. It's clear exactly what we have here. There was a document, it was not provided, and there was other information that was
Let me ask you this question. if the court felt compelled that it had to allow some of this information, even if I do find a discovery violation, I just want to know the state's position as it relates to a need for time to investigate some of this information that you're literally learning five and a half weeks into a trial.
Judge, the testimony yesterday that all of a sudden she looked at a text message and said read without the document, I don't give it much credence. The document's clearly not admissible. Her having testified that it was read.
Well, you know the document exists.
Yeah, but I mean, I would submit to the court it's clearly inadmissible. There's no question it's clearly inadmissible. It's provided after she said something on a witness stand. Judge, I worry about the credibility of what's been provided, how it was provided, how it became read. I have no idea, nor am I ever going to be able to know. No time is going to allow me to figure out how that became read. It's just impossible at this point in time. So I don't believe, personally, I don't know if Ms. Walls would disagree with me, that time is going to do anything at this point in time. It's not going to allow me. I know I can find out when Ms. Caneiro's phone number was ultimately ported to someone else, which is what happens when someone's phone is ultimately canceled. But that doesn't provide access to the data within the phone in order to allow someone to read a message after the fact. It's just that document is just clearly inadmissible. Whether the court ultimately tells the jury to disregard the testimony about it, that would be the state's position. But as far as time, Judge, we try to move this case as quickly as we could in an expeditious way, in a thorough way, and the state is ready to finish this case.
Ms. Massalone, would you agree with me that the document, the screenshot that you had, was an electronically stored document within Katie's phone?
The document that I had, Judge, was simply a screenshot of what she observed in live time.
So, but my question to you is that the actual physical phone that documents the screenshot, that physical phone and what's located there, do you agree with me that's an electrically a stored document within her phone? Do you agree?
From the moment she took it, sure.
And from the moment that you knew about it, correct? It's an electronically stored document, right?
I don't know if that's within the context of the discovery.
I'm asking you a question, yes or no. The answer is either it is, or in your opinion, or it's not. So
In my opinion, it is electronically stored in her phone. Yes, is it electronically stored? As far as do I have access to her phone? I didn't have access to her phone.
Well, actually you did, because you actually got a screenshot of it, according to you, the day before, so you did have access to, not only to her phone, but the fact that you received a screenshot of it. Am I correct?
I would disagree, Judge. I'm on the phone with Katie. She's giving me information in live time. This is less than 24 hours before she's set to testify. And she informs me of something for the first time, and in live time says, and by the way, here's a screenshot of it. So this is less than 24 hours before she's testifying. It's not clear that this is, my understanding is if I'm not going to actually use the physical item, I didn't think it would be necessarily fair. I have to say, I had a fleeting moment to really think about it. But I didn't think it would be fair to surprise the state with this document and say I'm going to use this tomorrow or I plan to use this tomorrow. So I relied on what she verbally told me to elicit the testimony. I think those are two distinguishable things.
I don't think they are. I don't think they are at all. I actually think that you had 24 hours, according to you, if you're actually assuming your information is correct, that you had a significant amount of time that you had a screenshot of information that you knew you were going to elicit the next day, and that you did not turn it over. You didn't turn it over on Sunday. You didn't turn it over on Monday morning at 8 o'clock when we're all here a half hour before we started. You didn't turn it over at the first break at 9:30 or 10 o'clock. You didn't turn it over at the second break that we had at 11:30. You didn't turn it over at 12:30 during the break at that point in time. And you obviously didn't turn it over even after you asked the question about it. It wasn't until it comes up where I'm getting a brief at 10 o'clock at night, some 6 hours after the testimony, for the first time, the screenshot shows up and is now a part of this case. So, yeah, you did have time. You absolutely had time to turn it over, and it's not a fleeting moment. You knew with other text messages that you had, where you got somebody's phone records in the past, you actually turned those messages over. So you know that you actually have to turn over something that's in somebody's phone because it's electronically stored information. And the reality is that you decided not to do that. You intentionally and deliberately decided not to turn over discovery that you had in your possession before such time that that witness took the stand. So the state, at least at that moment, could have had the opportunity to say, hold on for a minute, we want to do some research on this before it comes out on the stand. Tier says one thing, it does. But Tier does not mention, and it does not deal with the fact, when something, it's not created by you, no one's asking you to create anything in this case, it already existed. This information was stored in her phone. It existed. You knew about it. You didn't turn it over. There's a difference. That's not what Tier is talking about. This, in this court's opinion, aligns more with State versus Knight. That is a 2024 decision, which I'll get into in my decision, which directly, in this court's opinion, is a situation where the defense has certain rights, and they absolutely, there is, I'm going to use the word imbalance, but only to the extent to preserve the defendant's constitutional rights. The defense does not have to turn over as much information that the state does. However, the discovery rules make it clear that electronically stored information needs to be turned over. You had it, and you didn't turn it over. So if your answer is anything other than, when I ask you if it's electronically stored information, if the answer is anything other than yes, it is, I got a problem with what you're saying. So I'm going to give you another opportunity as you're talking to the court. When you look at this information, is it or is it not electronically stored information?
Judge, frankly, I don't know. I don't think it's clear. Again, my interpretation of the discovery obligations are that if I am using something at trial, a physical, extrinsic document or piece of evidence, then I have to turn it over. And there were many things that were turned over months ahead of time because I had them months ahead of time. All I can say is I had this item the day before she was going to testify, and if I had not had the item, if it wasn't sent to me, and all I had was her verbal information, I would have just elicited the testimony. So I was relying on the verbal information, not the extrinsic information, to elicit the testimony. And that's all I can say.
That is.
If Your Honor disagrees, then Your Honor disagrees. That's all I can say.
I do disagree, because you know what you're doing? You're trying to walk a fine line and a tightrope on this situation, but you know that electronically stored information needs to be turned over. So that is why you're saying, I'm going to rely on the testimony that you know has electronically stored information to it. You know it. And you decided in a deliberate attempt to not turn it over, that you would just elicit it on the stand outside of turning over the physical screenshot in advance, so the state has some clue as to what was going on. The state didn't even have the opportunity to object. It happened so fast. So the reality is simply this. I hear you as it relates to this issue. I 1,000% disagree. This is not what the Supreme Court at any point in time contemplated when it considered tier. This is not what it did. There's no way. And when I look at State versus Knight, it shows me that there are certain situations where the defense has to comply with the discovery rules. And this is not going to be trial by ambush, not in this courtroom or not in this state. So that's number one. Let's move on from the text message for a minute. I want to talk about the issue of these locations from February 2019. The electronic location that she looked at from 2019, is that stored in her phone as of today?
Not that I know of, she's just relaying what she saw back in February of 2019.
That's not what I'm asking you. I'm asking you whether, obviously, you're having a conversation with her as it relates to the other text message, and there, she's like, I have a screenshot. I can't sit here and not think that somebody who's preparing a witness in a case like this wouldn't ask a question. Do you have anything in your phone that says that the location comes back to Corey's house in February 2019? Are you saying that you never tried to see if that information's electronically stored in her phone?
That's exactly what I'm saying. I didn't ask that question because she just mentioned that when back in 2019 she looked at it and saw that it said that it was at Corey's house. And because I was under the impression that they obviously had the iPad at some point but never seized it or searched it the same way that they did to Sophia's phone. And just so that the record's clear, I also want to note the text message that she sent to Jennifer, the state did a cell phone extraction. They have her cell phone extraction. When I refreshed her recollection, I wasn't using...
I know you weren't. That's what makes it even worse. You decided to use an electronic document that you know was not 100% accurate, because the document that was 100% accurate to refresh her recollection would have been what you had in your possession, which was the screenshot, which included underneath the word read, which is what you supplied in your exhibit. So you had something, again, in your possession that you consciously decided not to turn over. And then when you're deciding to refresh somebody's recollection, you decided to use a document that, okay, this is in discovery, so I'll use this, but then I'll ask questions and get a verbal response as to the other information that's electronically stored in the phone. That's not appropriate. It's not in any way, shape, or form. The other part of this is that you're saying in your footnote on page 2 that defense counsel further recalls the witness mentioning, so I guess this is during a conversation that you had with her, that she confronted Corey about it, either text or phone call. Do those exist?
I don't know, Judge. I'm being in candor to everyone. I'm just relaying the context of the conversation and what was told to me. That's all. The court is clearly being accusatory toward the defense. The court is using words such as conscientious or conscious and deliberate and intentional.
I'm using it because it's true. I'm using it because it's true, Ms. Maslone. So don't say that I'm using these words for any other reason, because you did this. I didn't do it. I've given you the opportunity to ask questions and do whatever you need. And the reality is, you can roll your eyes for the record as you just did, but the reality is simply this. You were given the opportunity under these circumstances to turn over electronically stored information, and you didn't do it.
If that's the court's finding, then that's the court's finding, Judge. It doesn't seem to me that there's anything that I can say to further my position that this was not a discovery violation, nor was it an intentional discovery violation. So if the court finds otherwise, and the court clearly has, then there's nothing further that I can say. The defense has made every effort to try to be transparent in light of the fact that of the unique nature of this case. I've never had a case where I've had to go to sidebar so many times to make sure that it's okay to ask certain questions, as I did before Katie Caneiro's testimony. This was not something that I anticipated would be an issue. I elicited something that she verbally told me, and that was it. There's a 25-page ex parte letter that pertains to Corey Caneiro. The court made rulings. I advised the witness accordingly of what she was and was not permitted to say. This was something that came up at the last minute that didn't seem to me to have, the message about Jennifer's phone has nothing to do with Corey Caneiro.
Didn't I rule as it relates to any post behavior by Corey and/or his wife or ex-wife that I was not going to allow some of this conduct to be brought out? Didn't I say that in my January 27th?
Absolutely, and this wasn't.
Okay, so hold on.
It was just failure to investigate and seize and search the iPad.
No, it's actually not, because the first thing that you say
is that people were in the home.
I'm sorry, I think I was talking. The first thing that you say deals with the fact that they are in the home. They are in the home taking stuff out. It demonstrates that Corey was taking items from the house after the homicide, which lends to further credence to the defense's earlier point.
Yes, exactly.
The reality is this: it goes to his behavior. It doesn't go to the fact of something that happens in 2020, a contamination of the scene in 2020. It's not like we have evidence here of Corey's DNA in the kitchen so that we have some contamination issue. What this evidence is being used for is to show that Corey is actually in the house just taking items out, and it goes to his behavior. That's what I find. It goes to his behavior, which is exactly what, in my January 27th order of a 42-page opinion, which I said specifically that area of testimony was not going to be allowed.
It wasn't elicited, Judge. If I can clarify, I was simply explaining that the Tiffany's boxes, those photos, those were taken in 2000, I believe, to early 2019, around the same time frame by the insurance company, if I'm remembering correctly. That was testimony about the Tiffany's box that was elicited, and Your Honor, I think, had said it goes to scene contamination because the swabs were not taken for an entire year later. Additionally, there was testimony about Elisa taking shirts or clothing from the house. That was prior to the swabs being taken. So there is testimony.
Who testified to that? Who testified to Elisa going into the house and getting stuff out?
Judge, could I just,
It might have been a mix between Petrozello and Detective Vogt.
I think there
Who
was.
specifically testified that people went in the house, that they saw them go in the house and take stuff out? Or contaminated the scene?
Well, that would be Detective Vogt, not specifically as to the shirts, but as to the jewelry boxes on the floor of the master bedroom.
That he says what?
That he didn't place them there, that they appear to be the same type of boxes that were in the safe that was opened, and that he does not know how they got there. And clearly from the photo, they're on top of the fire jar.
I remember that. But who testified that somebody went in there and actually was touching this stuff?
Well, Detective Vogt did say that the person from AIG must have been in the house.
Okay.
And there was no.
You know what I'm asking you. We're not talking about AIG. We're talking about the fact, what's being said to me right now is that there was testimony that Elisa was in the house. Where in the testimony does it actually say that? Not based upon what you guys may know outside the testimony. What do we have in the testimony that says it?
I don't, I mean, at this point in time, I don't specifically. I don't have a recollection of exactly where that came in the trial.
Okay.
I know I can say it didn't come in through Detective Vogt.
Right.
It may have come in through Detective Petrozello. I can't say for sure. I know it's a fact we knew, I know it's a fact we discussed. I don't know if it came out in the testimony.
Here's the problem that I'm having. I'm saying it to both of you. And I've said this before. You two know more about this case than everybody because you have institutional knowledge, number one, for having this case, but number two, about the intricacies that were going on behind the scenes. Just because you know it doesn't mean it was in the case. I'm having struggles even with this submission because there's other parts of this submission that is talking about testimony that has occurred that I don't have any recollection of, or in notes and notes and notes, can I find it? So I'm not saying that I'm right. That's why I'm asking these questions, because I don't think it exists, and I may be wrong. So if you tell me that it exists, I will go and try to find it. Otherwise, I don't know how we're getting to certain leaps to make these connections without some testimony to support it.
Judge, the portion in the letter where I'm referencing it was just for context. It wasn't to say, it was for why this could be relevant. I wasn't eliciting specifically that Corey was in the house. That wasn't part of the testimony, and really, I guess I should have switched them, because I think the main reason I'm relying on it as probative is simply because it's a failure to investigate. What I also didn't include in the letter, because it wasn't something that also was not testified to, is that there was information contained in the discovery about Jesse sending text messages that his house was on fire. Now, whether that's a credible, piece of information, I don't know. It was in the discovery, and they don't have the iPad. So, from the defense's perspective, the fact that they did an extraction of Keith's phone, did an extraction of Sophia's phone, I never knew what happened to Jesse's iPad. I learned for the first time the day before she testified, or maybe it was a couple of days before, about the iPad, that she checked the location and that the rest ensued. I don't have any additional information other than that, Judge. It was a relevant fact to elicit. The state objected. If the court finds that the information shouldn't have been elicited, the court can obviously sustain the objection and or strike it. With respect to the iPad, there's nothing for me to turn over. I don't have anything. It's not, and I don't think, I do disagree with the state as far as what TIER is designed to say is to protect the defense's Sixth Amendment privilege and right to conduct a
This isn't a Sixth Amendment issue. It's electronically stored information, and it's not inculpatory against the defendant in any regard. Yes, I understand what you're trying to use it for, but you're trying to use it because the investigation could have been done better. However, you're trying to give context to things that are not in the case. And I've already ruled that certain information was not coming in. And what we're trying to do in this scenario is trying to elicit information for one reason and then leave it out there for whatever else it may be used for. And my problem is that I understand that for third-party guilt, that I should give as much credence as I can. These are not the exact words from the case law, but to try to give you the opportunity to do what you need to do. But this, I've ruled on this, and I think that this was something that's very concerning to the court. I'm going to take a few minutes before I make a decision. Prosecutor, is there something you want to say before?
Judge, I just want to clarify something that really is just for clarification purposes with respect to there was information in the discovery that Jesse may have texted other people that his house was on fire. That is accurate. Detective Mahoney's notes indicate that he had heard that. He then, other people, I don't remember exactly who, went to the school and determined that that was not in fact true. It was a rumor amongst 11-year-olds in school. So that's just to close the record in that regard.
I'll be back. Let's not bring up the jurors yet.